Hi, I'm Metta Spencer. Today, it's high time that we talk about enforcing international law, don't you think? And so I have two experts here who are going to discuss between themselves the current developments or recent developments in the application of international law and to war crimes and crimes against humanity and that kind of thing. So I think that is the way forward for us to try to get peace by law enforcement, first of all. I'll introduce first Rebecca Shute, who is already, I've forgotten the title that she's just given me. Rebecca, say it again, please, dear.
Sure. I'm the Executive Director of Citizens for Global Solutions and the co-convener of the Washington Working Group for the International Criminal Court.
That's perfect. Very good. And Lawrence Whitner, I should be able to remember your credentials because I've known you so long. You're a professor emeritus of history at the State University of New York at Albany, right?
Yes, that's correct.
Mm-hmm. All right. Now, there are a lot of things that have been going on relevant to international law, criminal international law in a way. And one of them has to do with the recent decision to what is the word that you use when you're accusing a head of country, an international lawyer or a leader of war crimes or crimes against humanity or something of that kind. You don't arraign them. You don't
Arrest.
And it's called a what?
Arrest warrant.
It is an arrest warrant. Okay. And it's used, that terminology is used. I'm glad, because my God, we ought to arrest some folks. I've got a list of my own. All right. So yes, there have been arrest warrants issued for people in Israel, and I think also for Putin. So those are high drama. Countries have to either decide whether or not they will keep their word and arrest these folks if they get a chance, or not. And so I want to talk about that, what the implications are of that. Rebecca has just returned from The Hague, where what is this outfit that you this meeting that you took part in?
So the governing body of the International Criminal Court is the Assembly of States Parties. The 124, soon to be 125 states parties to the ICC meet and decide very important matters such as the budget, such as resolutions on amendments, new crimes. And in this case, I think we're going to be talking a lot about the dialogue around cooperation. And so this has been held every year since the court came into its functionality in 2002, and alternates between The Hague and New York.
Okay, now the thing that drew me toward both of you was that I received an article, a short piece by Larry recently about the failure of the world's the largest countries, the most powerful countries in the world, to support and accede to and carry out the orders of the International Criminal Court. And of course, that's really what we need to start dealing with. Larry, I think a good beginning would be for you to kind of give a review, if you will, of the article that you just published in, I think, Foreign Policy in Focus, and probably some other publications around the country.
Yes, thanks, Metta. The basic point made in the article is that the major military powers in the world are very sensitive when it comes to having their own officials indicted by the International Criminal Court. The court, which became functional in 2002, is authorized to investigate and prosecute officials and convict officials for genocide, crimes against humanity, war crimes, and the crimes of aggression. And it began doing so in 2002. It soon found that although most of the world's nations have signed the Rome Statute, the authorizing international treaty for the International Criminal Court, the major military powers were not as pleased by the founding of the court, and indeed began to object to it and to hinder its role during the ensuing decades. Although U.S. officials, as officials from other countries, played an important role in creating the court, when it came right down to it, the U.S. government, for example, backed away from the court. President Clinton signed the statute, but never brought it to the Senate for ratification. He passed along the issue to his successor, George W. Bush, stating that he had certain objections to the Rome Statute and to the practices of the International Criminal Court on the basis that it could prosecute U.S. officials, and so he thought that the jurisdiction had to be changed. President Bush was considerably more hostile to the court, and he unsigned the statute for the United States, and he brought to Congress, I believe it's called the American Service Members Protection Act, which was designed to get U.S. military officials off the hook for war crimes against, I forgot now whether it was Iraqi or Afghan war crimes, but nonetheless, Bush and Congress, which passed this legislation, were horrified by the prospect of U.S. military officials being investigated and prosecuted.
Excuse me, but which officials would have been prosecuted? Did they name at that point the particular generals, or maybe the president of the U.S. himself might have been?
My understanding is they were not named, but there was some discussion of that prospect, and that so horrified the president and Congress that they quickly took actions. The U.S. government was hostile to it at that point, overtly so. In the following years, the Bush administration and the Obama administration actually softened this hostility toward the court somewhat, thanks to the fact that the court didn't prosecute U.S. military officials for war crimes, but moved on to arresting some of the most heinous violations of human rights, or African officials for some of the world's most heinous violations of human rights. And Bush and Obama could go along with that. That seemed to make sense. It didn't harm the United States in any way, and that's how they wanted the court to function. But of course, in subsequent years, as the court expanded its activities and began to convict people, and the Trump administration came to power for its first term, President Trump was more wary, based on his America First policy, which basically rejected any sort of international institutions that might interfere with anything that the United States government wanted to do, like the United Nations, for example. So the International Criminal Court was attacked by the Trump administration, and the Trump administration imposed sanctions and travel restrictions on top officials of the International Criminal Court. Again, there was some drawing back from that harsh stance by President Biden, who welcomed the court's activities in investigating war crimes in Ukraine by the Russian government. But of course, now that the U.S. government rejected the warrants for the arrest of Israeli officials made only last month, there's a tremendous furor that has developed inside the U.S. government, and the House of Representatives actually passed a bill to sanction the International Criminal Court. This was blocked in the Senate, but when the new Trump administration comes to power, it looks likely that there'll be further action towards sanctioning the court and overall undermining its authority. And similar things have happened with respect to the Russian government, which had initially signed the Rome Statute, but immediately withdrew its signature after the court began to investigate Russian war crimes in Ukraine. And that's true of other countries too. So that basically the great powers don't want their own officials to be investigated. The prosecution for war crimes is to be for other countries, not for theirs.
Right. Well, refresh my memory, because it's been a year or two or more since Putin was charged. And I thought that I can't remember what the charge was. It ought to be that he is charged with aggression, but whether or not that happened, I don't know. But I remember there was something about his removing Ukrainian children from their families and putting them in adoptive families throughout Russia. And this was the worst thing they accused him of. And I thought, this is not a very bad. I wouldn't have charged him with that at all. But I can think of a lot of other things I'd call him. What was it that they charged him with?
I'm going to let Rebecca respond to that.
Sure. No, you're absolutely right, Meta. It was the alleged war crime of deportation of Ukrainian children, which is a war crime under the Rome Statute. The crime of aggression should have an asterisk next to it. It does not have the same jurisdictional validity as the other three core crimes of the Rome Statute, and there has never been a case yet of aggression before the ICC. There are numerous efforts to solve these lacuna, including led by the wonderful Professor Jennifer Trahan and her Global Institute for the Prevention of Aggression. And if there's an opportunity to share links and resources, I would be happy to do so. I won't get too into the weeds on that, but this was a crime where there could be a clear command responsibility linked to Putin and also his child rights commissioner, Maria Lvova-Belova. Subsequently, war crimes were also alleged against two senior officials with regards to the lack of distinction and basic violations of Geneva Conventions that are now enshrined in the Rome Statute with regards to targeting of humanitarian lack of distinction and also targeting of humanitarian outlets as war crimes.
Oh,
So that
so
is,
there's there's a term called lack of distinction, meaning if you treat humanitarian agents as eligible to be persecuted, uh, you get charged for it. Is that it?
so the principle of distinction is one of what normally is referred to as the four fundamental principles of international humanitarian law. And it means that parties to an armed conflict must at all times distinguish between the civilian population and combatants to the best of their ability. So, there's fog of war excuses, et cetera, et cetera. But there must be an attempt to distinguish between civilian objects and military objectives. And civilian objects should only be targeted to the extent that they are absolutely necessary. And then there's a principle of proportionality that comes in. And so, obviously, some of the actions that are alleged to have taken place with regards to Russian aggression are fail to meet that principle.
Well, the whole change in military practice for the last I don't know, at least 100 years, maybe less. If you think back to World War II, the bombing of cities by Allied forces, as well as the other side, I think you can't really claim that they were protecting the civilians.
No, and that's what led to the whole development of the corpus of international humanitarian law as we know it today, the Geneva Conventions coming out of World War II, and that continue to evolve through their optional protocols. So it was very much not only in response to the horrors visited by Axis forces, but by allies as well. And so the Geneva Conventions of 1949 were adopted after World War II to update 1929 treaties and add new conventions. And so they went further in expanding these core principles that I'm mentioning.
Well, that's lovely if I could see any change in practice. But has there really been a corresponding reduction in the use of violence against civilians during this transition to this new international law?
Well, I think one thing that's important to remember, this is the 125th anniversary of the First Hague Peace Conference. And before that, the law of war was the natural state. It was not seen as the last resort. It was not seen as something necessarily that should be regulated or that should be avoided. And so the fact that we have laws governing the conduct of conflict is, I think, a feat unto itself. And I will say that I do think that both the ICC and the ICJ, the International Court of Justice, which maybe we'll get to talk about a little bit, as well as other regional courts and domestic jurisdictions that have enshrined these within their own national laws, do, by and large, recognize now that there is a legal obligation. And so we know that when it's flouted, it is being flouted. And whether or not we're going to get to the enforcement, we're going to get to the implementation and how difficult that is when you have recalcitrant states that won't cooperate. But we now say that is wrong. That is not only wrong morally, it is illegal. And we did not have that recourse and that rationale prior to fairly recently. And the Rome Statute has taken the corpus of international humanitarian law, the law of war, and extended to individual personal responsibility, criminal responsibility. And that is one of the many important contributions of the ICC. We could also talk about some others. And it continues to be an evolutionary process. At The Hague 2 weeks ago, we were discussing adding new crimes under war crimes and crimes against humanity, the slave trade and the crime of slavery, which only appears in certain ways currently in this statute, but is not an independent crime as a war crime and a crime against humanity, as well as the crime of ecocide. And ecocide and environmental crimes environmental crimes have been contemplated by the current prosecutor within his strategy as priorities to address as war crimes and crimes against humanity. And when you think about Ukraine right now, And when you think about the situation in Palestine, which is what it's called in the ICC. I'm going to use that terminology. This is not a political statement. This is the terminology of the court. We see the validity of those crimes being actively prosecuted.
Well, I apologize. I think I came at you with a kind of cynicism that is not useful or really appropriate. It's my bad day or something.
No, that's the number one, I think, question that folks like me get on a regular basis. And if we're not able to answer it, then we have no business being here. So,
well, I mean, I think from my point of view, the key to progress in getting rid of war is exactly to have some real effect, predictable. A war criminal should have to expect to be arrested and put on trial and put in jail, and they aren't. I mean, by and large, I don't think Putin is losing any sleep, or Netanyahu either. And I guess maybe we could all think of some others that are out there on the loose. So to me, the really interesting notion is, how can we go about actually making sure that these international clauses are enforced? And I'm sure you have given a lot of thought to that, and probably Larry has too.
Let me add that in the case of the two recent attacks on powerful officials in Russia and in Israel, well, on the one hand, of course, the officials have not yet been arrested, but the enormous furor stirred up in both governments and in other governments too by the issuance of the arrest warrants meant that officials were getting very upset about this, that they did feel it, that they didn't like it at all. That is, if the court's activities had no impact, then they wouldn't, in fact, lose any sleep over it. But the tremendous opposition, the condemnation, the threats against the court by these powers show that these governments took this critique by the International Criminal Court very seriously. The Russian government, for example, after the arrest warrant for Putin and his head of the children's affairs there in Russia, after this, Russian officials denounced this, and in the harshest of terms. The former Russian president, Dmitry Medvedev, who is the deputy director of their National Security Council, threatened a missile attack on the Hague headquarters for the ICC, and warned the judges that they should look to the sky. And there has been similar rhetoric by supporters of the Israeli government too, and by the House of Representatives, so that this does mean something. This does bother government officials deeply. One other illustration: when Vladimir Putin was invited, was scheduled to go to South Africa to participate in the BRICS conference last year, the South African government had to deal with the fact that as a party to the court, South Africa was going to have to decide whether it was going to abide by the Rome Statute, or whether it was going to let Putin simply visit there and have nothing happen. And the South African government decided that they would uninvite Putin at that point, and they broke the news to him that if he came there, they would have to arrest him, and he didn't come there. He took part by Zoom, but he was embarrassed and humiliated by this action. So I think these governments do feel the sting of the criminal court's actions.
And that example that Larry gave is actually, I think, quite perspicacious of South Africa. Omar al-Bashir, who still is at large, traveled extensively to states parties as well as non-states parties while an arrest warrant was over his head, including to South Africa. I think it was for the AU summit. And he narrowly made it on the flight before being detained because the Constitutional Court of South Africa challenged the government on domestically at this point, because at this point, the ICC pretrial chamber had ruled in many other cases that states parties had an obligation to arrest Mr. al-Bashir if he was on their territory. And so this not only was an obligation that the ICC had imposed, but then South Africa's own court system ruled that it had an obligation, the government had an obligation to arrest. And so that time, Bashir narrowly got away and Putin didn't go. And just this week, I think actually yesterday, it seems that Mr. Putin has canceled a trip to Poland. Mr. Netanyahu has canceled a trip to Poland for the Auschwitz commemeration. Which
I was amused that you're almost saying that Putin was going to Warsaw.
No. Mr. Netanyahu canceled a trip to Poland. But Mr. Putin recently traveled to another state party without being arrested, to Mongolia. Mongolia, not one of the most powerful states, in a difficult position between the Russian Federation and PRC. And at the Assembly of States Parties this week, it was quite embarrassing, honestly. There was very little that the Mongolian representative could say to defend their actions at this point. And to be honest, I just got off a call with the Washington Working Group from the ICC, and our consensus was, well, I guess the states parties kind of went easy on them because poor Mongolia. And that's not okay. And it was even more glaring because there's currently a Mongolian judge on the court. So that cognitive
and actually, the Mongolians, I think, have been exemplary in their effort to really become a democracy. They've done wonderful things, quite a few exceptional things. So it must be very hard on them to feel that the pressure of their neighbor is so intense that they can't afford to do what they would probably be inclined to do.
Right.
Only guessing, but.
Yes, and there's another inconsistency here as well with regards to what we call non-essential contact of intergovernmental organizations with individuals with arrest warrants, which is that Secretary General Antonio Guterres met with Putin as well, quite recently.
Oh, yeah, that is,
to meet with him.
I think that's harder to take.
And so, yes, if you are looking for state compliance, it's a little bit difficult to stomach that, honestly.
Mm-hmm.
I would also like to make a couple points here about cooperation by non-states parties. I think you got a real rich sense from Larry's introduction that the U.S. engagement with the court has not been linear and has not been consistently negative nor consistently positive. And I think sometimes we miss some of the latter. The first two individuals to be convicted by the court were surrendered with U.S. cooperation to The Hague. They would not have gotten to The Hague without the United States. So too with Dominic Ongwen, who recently on appeal was convicted of war crimes and crimes against humanity in the context of Uganda, and the largest reparations order of all time is now being paid out, of the ICC is now being paid out to
who's paying what to whom? I don't get it.
So the ICC has a reparations when there is a conviction and it's upheld on appeal. If there is an appeal, It has the ability to make reparations to victims and affected communities. There's also there's an independent entity called the Trust Fund for Victims that has a dual mandate for reparations and assistance. And I'm going to talk about this a little bit more if you'll give me the indulgence, because it's another method of cooperation. So the Trust Fund for Victims, when I say reparations and assistance, a defendant like Dominic Ongwen is indigent. In most cases, I think all of the, except maybe one, of the folks who have come before the court, not the heads of state who have arrest warrants hanging over them who have not appeared, but they have been indigent. So how can you possibly calculate the damage to victims and communities and then pay that out? It's state party contributions, but it's also non-state party contributions. Non-states parties can contribute to the Trust Fund for Victims. And this is a little bit controversial. But
Hold on now, what is state parties, victims only, well, normally would be expected that the victims would be the recipients and they should be trying to get the money out of the perpetrators.
Right. If the perpetrators don't have money, if they're indigent, that's why there's the fund.
So we can all chip in to make up for the fact that the bad guys are broke. Okay.
Yeah, basically. And we can all chip in, including the United States, a non-state party that has contributed frequently to the Trust Fund for Victims. And this is a little bit controversial, but where states parties cannot earmark where their contributions go to the court itself in terms of judicial proceedings or prosecutions or investigations, there can be earmarks with regards to the trust fund. And those can be situation dependent. We want to see this go to Ukraine. Or it can be topically or contextually dependent. We want this to go to sexual and gender-based crimes across situations. We've seen a lot of that recently with both states parties and non-states parties. So those are two important ways that the United States has actually worked with the court. We've also, Larry mentioned the American Service Members Protection Act, which really curtailed the United States from cooperating with the court in a lot of respects. And then there were some carve-outs with something called the Dodd Amendment. And those were enshrined in the Congressional Authorization Act with regards to Ukraine. And so we kind of skirted around, and again, this is kind of controversial. I mean, how above board this is. And we're able to offer some assistance to the court with regards to its cybersecurity and its ability to successfully, or not successfully yet, but to investigate war crimes and crimes against humanity that have to do with technological aspects that render the court itself vulnerable. Last year, the court was subject to a major cyber attack that was linked to the Russian Federation. And so there, U.S., both private and public sector.
So Russia is actually going around and trying to hack the...
Oh, it did. It was hacked. Yeah.
Wow. Okay. All right. Well, now this brings me close to another issue, which isn't about crimes exactly, but there is a dispute about the money that the Russians, and I don't know how much of it is government money, how much of it is private holdings, but investments and in other countries. And some of it has been taken and allocated to boy, now I'm up against, what do I remember? There are two levels, I gather, of which many countries are willing to go so far, but not all the way. Really, I think Canada might very well propose. I had a conversation with Lloyd Axworthy about this a long time ago, and I think he favors the idea of really confiscating all these Russian holdings, zillions of dollars in Europe and North America and God knows where else, and simply giving it to the Ukrainian government to help rebuild. Is this is this in your bailiwick? Are you interested in that issue? And I gather it's still simmering. There's no definitive answer yet.
Larry, do you want to go first, or?
Not really. I believe that it's not an issue covered by the International Criminal Court. I believe that has to do with overseas assets of the Russian government and whether they should be seized by the governments that hold them, and thus violating Russian property rights. But of course, in the context of the war, it seemingly makes sense to reimburse the Ukrainians through these overseas holdings. I believe
it's even they wouldn't refer to it probably, but there's an even more compelling argument for that, and it's simply that these guys stole the money in the first place to buy their yachts and all these other perks that go with being an oligarch or being part of the system. So it's very clear that most of the money is tainted from having been taken improperly and embezzled or various kinds of corruption. But I'm sure that would never come up in court.
Well, with regards to the ICC, excuse me, the ICC itself can't freeze or seize assets, but it requests that states parties do so. And that's another element of cooperation. We've been talking about cooperation heretofore in terms of arresting, but the obligation to freeze or to comply with a request to freeze and seize assets belonging to individuals accused of crimes under the court's jurisdiction is another method of cooperation. And of course, independently, entities that are not state parties to the ICC, such as the United States and the European Union, which by virtue of not being a state, even though all its member states are parties to the ICC, is not a Rome Statute member. So they have already imposed significant sanctions against Putin and numerous other Russian officials. The rubber hits the road when it comes to the difficulty in recovering those assets. We're not, dealing with neophytes here. You're dealing with some of the most sophisticated, multi-layered systems of asset, of hiding of assets, of mislabeling assets, transferring of assets. And so here there's actually a proposal that the organization that I'm executive director of, where Larry is on our board, supports for another court called an International Anti-Corruption Court that would specifically go after these illicit financial flows that are so often linked to atrocity crimes and to other forms of international injustice.
You mean there is such a court, this corruption thing, or are you just proposing one?
No, it's being proposed, and I'm delighted to announce that as of last week, the first draft of the statute is completed. I participated in that effort. And there are a couple of states that have, more than a couple, several states have already indicated their support. And I think more than 200 former heads of states, Nobel laureates, other eminences have as well. And so this would solve a major lacuna in international law because corruption was contemplated, as was terrorism for that matter, as a potential crime under the Rome Statute system, but was not included. And I think that's a very good thing. The Rome Statute is the court already has enough to do, and this is a very complicated set of crimes that are embedded in the catch-all term corruption. And it's not a human rights issue necessarily under international law, so it's beyond, in many cases, European Court of Human Rights, the Inter-American court system, or the African court system. And so you really rely on domestic jurisdictions, which these are massive, massive investigations, and they might not always have the capacity. Even in the United States, it's a major effort to implement the sanctions that we have in place. And the Magnitsky Act and the Global Magnitsky Act are wonderful tools to sanction individuals accused of heinous crimes and of grand corruption. But it is very difficult to then prosecute them. And so this court would, I think, take a major step forward. And while Meta has a little bit of a break, I can say that at this time where there is maybe increased skepticism of international courts and tribunals, one could ask the question, why another? But what we've seen here, I think, in the course of the development of the IACC, the International Anti-Corruption Court proposal, is how it can work with the existing courts and tribunals, both at the domestic level and at the international level. And so we have kind of horizontal complementarity, as well as the traditional vertical complementarity that we talk about with states and with international actors. So those are some things that are on the horizon, I think. And I will also just say that while there is maybe increased skepticism of international courts and tribunals, they've actually never been busier. And that goes for both the ICC and the ICJ. The prosecutor in his annual presentation, his annual report to the Assembly of States Parties, noted that the evidence gathered by his office doubled in the past year. Now, not doubled over the previous year, doubled in terms of the overall amount of evidence they have in their possession, given the size of some of these situations and in the investigations. And so when you look at the overall number of convictions, when you look at the overall number of arrest warrants, yes, it might seem small, but given the magnitude that we're looking at, it's quite incredible. And similarly, we haven't talked about the ICJ at length yet, the International Court of Justice, but it is currently seized of about 24 cases. And when you consider that it's looked at 125 since its first in 1947 and its founding in 1945, that gives you a sense of how many, how busy it is, and without a substantial increase in resources behind it. And in addition to the number of cases increasing, they have diversified in scope. So the ICJ is currently seized of 4 cases of genocide, alleged genocide, numerous cases of crimes against humanity and war crimes under various, war crimes and other human rights violations, for example, under the Convention of the Elimination of Racial Discrimination. And an unprecedented request for an advisory opinion on the obligations of states with regards to climate change. So that really runs the gamut. And
I love the idea that you might actually get some protection of climate legally. That is news to me. Is the prospect realistic?
It was a unique week in The Hague because you had, when I was there recently, because you had on the one hand, the Assembly of States Parties of the ICC meeting, and then you had the first week of oral testimony before the International Court of Justice on this advisory opinion. More states intervened in that case, in that request for an advisory opinion, that opportunity to give oral testimony than ever before in the ICJ's history. I think double. Any previous case. More than one.
Which case again?
The request for an advisory opinion on the obligation of states with regards to climate change.
Okay, got it.
More than 100 states intervened, as well as several intergovernmental organizations with the ability to do so. And the origin, I'm sorry, I need to give the floor back to Larry soon, but the origin of that case, that request for an advisory opinion, is also very much worth spending a moment on for those who question the validity of international justice right now. So the case emanated primarily by the agitation of young people, youth concerned about their environment. Where? In the Pacific Islands. You had young Pacific Island students come together and first advocate to their governments that you need to bring this before the International Court. You need to bring justice. You need to bring this before the United Nations. And they succeeded in getting the way that it works to get a request for an advisory opinion is go to the United Nations General Assembly, and then the UNGA has to refer. It was a unanimous referral, the first ever unanimous referral in the history of the ICJ. And so when you see that level of intervention from the grassroots through states up to the World Court, as it's called, that gives one hope. And so we also, a couple months before the ICJ request, there was a similar advisory opinion before the International Tribunal on the Law of the Sea, a tribunal that isn't discussed quite as often. And it did find in a maritime setting, obviously, an obligation of states. So how far the court goes here, and how specific and technical are its recommendations or its findings, that remains to be seen. And because it's an advisory opinion, it is not legally binding, but it does have significant weight. And we have seen advisory opinions of the ICJ by and large complied with. And as opposed to a diplomatic process like the COPs, the conferences of parties to the climate accords, where everything is being negotiated and it's, quid pro quo, and I'll scratch your back, and maybe sometimes going down to the lowest common denominator. This is a independent legal opinion, and that stands for something, or at least it should. I hope it will.
Well, I would hope so too. And let's think boldly now. There must be in the world people who are not just satisfied to know that Putin and Netanyahu have to make sure that where they're planning to travel isn't to a country that will arrest them. Otherwise, apart from that, they can just stay at home and continue their atrocities, whatever it is they're engaged in doing. And there's no way to enforce any of decisions. And that's what troubles me, that the real decision of the court that war crimes are being committed and must be stopped, there's no way enforcing that. Now, surely there are people who are thinking in terms of making, maybe not this year, but as soon as possible, because this is, I would give this very high priority, some sort of enforcement mechanisms internationally that would maybe go through the United Nations and get legitimacy in from two or three different directions. But I would like to have them some sort of an agreement that if your country is suddenly charged, or if the leader of your country is charged with war crimes or aggression or crimes against humanity or something, and they are supposed to be put on trial, then you've got to get rid of them, and you can't run a government headed by a criminal. And if the ICC says that this guy is, in our opinion, somebody who must be put on trial for a crime, then you have a week in which to propose a different regime that's going to comply with international law. Otherwise, we're going to do something to you. And I'm not quite sure what that would be, but some kind of international sanctions that all countries would enforce very, very rigorously against the country that continues to support a leader that is charged with war crimes. Okay, tell me, is anybody proposing something equivalent to that kind of enforcement?
Well, let me just go a step back. The development of international law is fairly recent in human history, and it's been a gradual process too. The Nuremberg war crimes trials, which tried individuals for genocide and crimes against humanity, had to be developed outside the framework of international law, insofar as there was no law on that basis. So it was really ad hoc. It was a judicial system set up by the Allied powers, the victors in the war. And only in later years was that institutionalized as the International Criminal Court. And certain figures played a role in both, such as Benjamin Ferencz. So I think we have to view this as an evolutionary process. And while ideally, nations should be doing exactly what you're saying, Meta, the fact is that we haven't gotten there yet, unfortunately, but we can keep going. Both Rebecca and I are officials in a group called Citizens for Global Solutions, which is trying to support international institutions and to develop a world federal government. So it would be much simpler to enforce international law and prevent war and prevent worldwide poverty and a whole range of useful things on a global level. I'll turn the floor over to Rebecca, though, to follow up on that.
Sure. Well, I'll give an example of one of the initiatives that CGS and partners supports that could go a long way to curing systemic injustice and failures of the global international order.
Sorry, but what is PGS?
CGS, Citizens for Global Solutions.
Okay, got it.
So I'm the executive director, Larry's on the board, and to learn more about us, to contribute, to become a member, go to globalsolutions.org, please. There is very, very little that is asked, and a lot, I think, to be gained by being in a community, as I think many of your viewers would share our values that is dedicated towards better global governance solutions, and specifically Democratic World Federation. So coming back for a moment to some of the shortcomings of the current international governance system, which was in large part a case of victor's justice written after World War II. Let's remember that there were 50 countries that were present at the negotiation of the UN Charter at that point, a small percentage of the world's population, 4 women in the room. And then, of course, we have enshrined the Security Council, the veto, and over time, originally, the veto was supposed to be used in cases where states were marshaling forces for aggression, and that's what it was conceived of: troop movements. It was supposed to be under the very beginning of the UN Charter. The whole point of the UN Charter is to end the scourge of war. And so that was what the veto was meant to be used for. And over time, we, of course, have seen the veto used far differently. And I think one of the most glaring and just crushing examples is with regards to the Syrian Arab Republic. So the ICC has jurisdiction over a case or a situation in 3 instances. 1, when the prosecutor starts a proprio moto, or 2, when a state party refers it. And for both of those, there must be territorial jurisdiction. So either a state party national must have committed the alleged crimes, or they must have been committed on the territory of a state party. And Syria is neither of those things. So neither of those avenues have been available to pursue justice for the incredible crimes committed against the Syrian people by their government. The third way in which a case can reach the ICC, however, and it's done so in the occasions of Libya and Sudan, is by UN Security Council referral. And so here, for a decade now, subsequent prosecutors, Madam Bensouda and now Prosecutor Khan, have begged the Security Council to refer the situation in Syria so that they could prosecute war crimes, crimes against humanity, really, and potentially genocide. And and I believe around 20 cases, the veto was used, or the threat of the veto. In some of those, we don't even know when sometimes when the threat of the veto is mentioned. But by the Russian Federation, often joined with PRC, the People's Republic of China, to prevent the referral of the Syrian situation to the court. Now, with the amazing, I think, astounding, surprising to many of us, change in regime, perhaps there is the prospect that justice could be served. We have to, of course, determine that the the current administration can speak for Syria, and it would have to accept either become a state party or accept jurisdiction over this specific situation, which, by the way, is what Ukraine did. Ukraine is still not a state party. It will become a state party on January 1st. But obviously, the situation in Ukraine has been ongoing because Ukraine accepted the jurisdiction of the ICC, exceptionally first in the situation in Crimea and then over the subsequent aggression and related crimes against humanity and war crimes. And so we could see that in Syria. And so when you ask about a change in government, a change in administration, and the potential to bring folks to justice, well, I don't think that al-Assad is necessarily getting too worried when he's probably hanging out with Putin right now in Moscow. But there is the notion that finally, maybe victims and survivors could find justice. Now, while that seems very hopeful, I will also, just from a legal standpoint, point out a couple major concerns that those of us who support justice for Syria have. The main one is the destruction of evidence. That while we see the freeing of individuals from prison cells and the dismantling of the remnants of the prior order, what goes along with that is a huge amount of documentation that is potentially rendered null and void. And there are wonderful groups, the Syrian Justice and Accountability Center, I want to call out in particular, that have worked for years and years and years to prepare for this moment. But there's only so much that you can do to prepare. And we, really the word needs to be out that when a regime change happens, you need to be thinking before a judicial process is launched about everything that will be necessary to ensure that process can reach its conclusion. We've seen cases thrown out of the ICC before for lack of evidence or for failures in documentation.
Can we assume that the new regime, which everybody's still trying to suss out, figure out what they're all about, that they will preserve documents, evidence against the previous regime? Of course, I suppose maybe there's evidence against them too, someplace or other. But can we assume that they will want to see prosecution go forward and cooperate in trying to make it happen?
I don't think we can assume anything, but I believe that there are so many wonderful groups on the ground and around the world, for that matter, who are committed to, no matter how hard it's been over these years, to seeing justice for the Syrian people, that it won't be easy to deny their requests.
Mm-hmm. Good. Okay, back to Larry. You sounded happy with the slow pace of evolution, and I'm out there with a cattle prod trying to move it faster. What is your best estimate about how long it's going to take before we can get real accountability, that any government in the world that does something criminal and violent, such as war crimes, that are being charged with war crimes or atrocities of any kind or aggression, that they can count on being prosecuted and punished? And what are the steps that you would support, and maybe you are supporting, in work toward getting that kind of accountability created?
Well, first of all, let me say I'm not happy with the slow progress of international or enforcing international law.
I
I'm
was just
simply
trying
pointing
to-
to the fact.
I was just
Pointing to
being,
the fact.
I was just being provocative, dear. I wasn't really.
Yeah. Okay. Well, I'm pointing to the fact that there was nothing being done on those lines for the vast majority of human history, and suddenly we are seeing these things happen. So that's the positive side. The glass is maybe 1/10 filled at this point, and we have 90% of the rest to fill. But we had nothing before. And in terms of the future, I guess that's a matter of what human beings do to safeguard human rights. There are organizations that are worldwide, such as Human Rights Watch and Amnesty International, that are seeking to enforce human rights, that have been gathering documentation and mobilizing citizen protest around that issue. And there are groups like Citizens for Global Solutions and the international body of which it is part of the World Federalist Movement that are pressing to strengthen global governance. And if they make progress, then we'll see progress in enforcing human rights. I can't predict the future. I'm a historian. I'm better at telling you of the past. But I can say that it depends on what we all do to develop international law and enforce it on the world scene.
Okay, I'm fully in favor of enforcement as soon as possible, but I'm immensely grateful to both of you for the work that you're doing and for your organization, because I wasn't aware of it, and we should try to get people to go find out more about what you do and how they can support what you're up to. So I want to thank both of you. It's been extremely interesting, and I've learned quite a bit from you. So have a good holiday season, and thanks so much.
Yes, thank you, Meta.
Thank you, Meta. A pleasure, Larry.